Unemployment insurance. There are lots of things that might fall into this category. Disaster unemployment. We've kind of gone through a no man's land of that with COVID, and that has changed things dramatically in terms of protections that the federal government and the state of California have tried to implement to protect workers. Trade readjustment allowances, family medical leave, which we've already talked about. All of these things are there to protect people in ways related to health plans and benefits. I'm not going to go over the California Labor Code, but these are the chapters, divisions and chapters within the California Labor Code. You could read through that and see if there's anything interesting that you're wanting to look up. But this is just one tiny section of the Code of Regulations within, or laws, not the regulations, but the laws related to labor. California's Agricultural Labor Relations Act of 1975 describes and protects the rights of agricultural employees to make their own decisions about whether or not they want a union to negotiate with their employer about their wages, hours, and other working conditions. So it allows workers to make their own mind and own decisions about, do I want to be in a union or not? It's up to the worker. And this guaranteed that in California to the extent that the law is able to guarantee anything. So there's a California Agricultural Labor Relations Board that conducts elections. There's concerted or activity that is done together, cooperative and joint activities. So farm workers do not have to belong to a union to have a right to concerted activity. You can still try to negotiate or do things to protect the workers, to ensure safe and fair working environment. You don't have to be in a union to do that. A union just makes it more official, cleaner, neater, more easily documented. Employers, on the other hand, do not have to meet the employee's demands unless those demands are because of some sort of problem that the employer is not meeting federal or state regulations. If the employer is falling short of what's required by law, then yes, the employer does have to meet those demands. And there's other legal action. But if the employees say, we want this, the employers don't have to say, yeah, we'll give you that. The act makes it unlawful for an employer to fire, refuse to rehire, or discriminate in any other manner against an employee because he or she has supported a union, participated in union activities, or has exercised any of the other rights protected by the act. And certainly this is some things that have happened. When I said earlier, and I don't know if you thought badly of me, that bad things happened on both sides. Well, there was a hell of a lot of intimidation. You talked the wrong way about the wrong thing. You did support unionization or you didn't support unionization. The other side might have a talk with you, and that talk might be painful. And it happened a lot. A lot of people got beat up. A lot of people had their cars damaged or scary notes put on their front door of their house. A lot of bad things happen. Just leave it at that. And so this is actually making it illegal for the employer to discriminate against any employee who was involved in union activities. Now, that doesn't necessarily include illegal activity. Effective January 1, 2003, the mandatory mediation was implemented for employer, employee, or union negotiation. So you can get a mediator to help if there is an inability to reach a union agreement. Sorry about that interruption. I'm not in a sound studio. Anyway, so mediation is just when you have somebody who's acting as not a judge, but something like a judge. They are trying to read both sides, the needs of both sides, and come to a compromise. Now, this applies only if 25 employees during any week of the past year preceding the filing of their request for mediation. So if they're very tiny companies, again, it doesn't apply. In January of 2002, there was the Agricultural Employee Relief Fund. And essentially, if employees are unable to be found for 2 years, any money that an employer owes that employee must go into this fund. And I say employee or their rightful heirs, family or heirs. And that happens a lot. People just disappear and they're owed some money. Well, where does that money go? It's put into a fund that is held by the government. And so if a company goes bankrupt or somehow gets away without paying somebody who does rightfully or is rightfully entitled to the money, and the determination, the decision is that they were cheated out of some money and there's no employer left to take the money and give to them, well, the money comes from this employee relief fund. Eligibility to work. Federal law requires any new hire to establish eligibility to work in the United States. That's the I-9 form I talked about earlier that was established in the mid-'80s. You have to do something to show that, yes, this employee has at least made reasonable effort to show that they are who they are and eligible to work. Sometimes the documentation that they provide is questionable at best, and there are lots of people in agriculture who work under somebody else's social security number or something else. It happens. It's getting harder to happen, but it does happen. Immigration and Nationality Act prohibits the knowing hire of individuals who are not authorized to work in the United States. And unfortunately, with this act, who do they go after? The employee who's not eligible to work. And even though there are rules and consequences, enforcement for employers, it's rarely ever done against an employer. Certainly if it is done against an employer, the employer is given the proverbial slap on the wrist. And I don't think that's fair. I think if the employer is doing things they shouldn't be doing against the law, they should be held liable. So the Department of Homeland Security, DHS Form I-9 is the form you must complete. The employer completes this form on the first day of employment. Employees must certify their right to work. Within 3 days, they must show some minimal documentation. It can be a driver's license, social security card, I think Social Security card is actually the one that's required by or preferred by most and used by most. But um, either one, you don't have to show both, just either one: driver's license, Social Security. Boom, done. It is the employee's choice which one they're going to give you. You can't just say, here's my driver's license. No, 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 I want your Social Security card. No, if you give a driver's license, that's it. Game over. You did what you needed to do. They have to accept it if it looks like a reasonable, valid ID. Anti-discrimination provision of 86, employers may not request more or different documents than necessary. They may not reject documents that appear to be reasonably genuine upon their face. And you're highly encouraged not to photocopy or otherwise document what they gave you other than to write it down. They provided me a driver's license. It looked okay, so you check a box and then you write down their driver's license number. Done. They get their driver's license back. Some driver's licenses might look a little questionable. Does that picture really look like them? If you photocopy it, it definitely isn't going to look like them anymore. And then somebody comes in and audits your records. Well, how could you have been accepting this form? Grand Central Station. Anyway, you have to accept whatever they give you if it looks reasonable. Then along comes E-Verify. E-Verify is a new way to document eligibility to work. And US law only requires that individuals demonstrate they're eligible to work. And right now, the two options are I-9 forms or E-Verify. E-Verify is an internet-based system that allows businesses to determine the eligibility of their employees to work in the US. E-Verify is currently optional under federal law, but is required in some states, not in California, at least not yet. And in this case, it is the employer's choice, not the employee's. So if you go to a job, get a job, and they say, we're using E-Verify, you can't say, well, I want to use the I-9 form. You can't. If they're doing E-Verify, too bad. You've got to do E-Verify. E-Verify has some problems. There are false positives and negatives where sometimes an employee shows eligible when they really shouldn't, and other times when they're shown to be ineligible to work when they are eligible. And that's really unfortunate, because then people who have no problem, they have all the right documentation, just because somebody did something in the past, they were victims of identity theft, the employer cannot hire you because you're red flagged in the E-Verify system. And that really bothers me. I'm not a big fan of the lack of remedy if you are denied the right to work under E-Verify. And a lot of people, I've heard a lot of stories about people being caught up primarily due to identity fraud problems or identity theft problems, and E-Verify prevents them from getting a job. And now it's your problem. You have to prove and fix the system. You have to prove that you are eligible to work. Under I-9, the problem there is that it's really easy to game the system and provide false documentation and get employment. But a lot of companies have moved to E-Verify, and from the companies that I've talked to, from their point of view, the number of employees that have been wrongfully rejected due to a glitch in the system is so low that maybe they don't individually know of a single case in their company. So to them, it's not a big deal. Say that to the employee who can't find work. But a lot of companies, actually every single company that I know that went to E-Verify loves it. It's simple, it's fast, it's easily well documented. It gives you really good protection to show that you've done all you can to verify that the employee that you just hired is eligible to work. So employers love it. With some exceptions, there are employers in ag that are really concerned, that know for a fact that they have a lot of employees who would never pass E-Verify. I worked for a company that had, I would argue, half of our labor crew did not have a green card. And under E-Verify, half the crew would be lost. And with certain labor contractor crews, that is still to this day a huge issue. And so there would need to be something to fix E-Verify to allow some sort of guest worker program, something to make sure that the agriculture industry in particular has the ability to hire people who want to work. And there are lots of people who do want to work, but they can't under E-Verify. So if E-Verify became the law of California, not an option, it would be a problem. So when I said I know a lot of companies that have gone to E-Verify in ag, well, they're more the manufacturing companies, the support companies, the suppliers, and the distribution channels, not the farms so much. And I haven't talked to enough people about that specific question. I have no idea, to be honest, how many people, how many companies that are actually farming operations use E-Verify. I have no clue what that percentage is. But certainly in other support areas, it's getting more and more common that companies will choose that option. Farm labor contractors, essential part of California agriculture. These are special businesses that will have labor crews for harvesting, for field work of all sorts, thinning lettuce, weeding crews, you name it. And so the farm labor contractors can supply large numbers of employees very quickly and keep those employees very busy by moving around to different operations. So if I've got a strawberry harvest operation and I'm picking strawberries every day, maybe I can have my own labor crew. But if I've got a lettuce operation, I've got a different issue. I've got high labor days where I'm thinning lettuce, where I'm harvesting lettuce, and a lot of days where I don't have enough for the crew to do. I got nothing for the crew to do. So by having labor contractors, the workforce moves around in the region doing work on a contract basis. So if you are a labor contractor, you still have all the same requirements as any other business. Tax reporting, you have to provide insurance. Bonding is providing money. So if anything goes wrong with your company, you show that you are financially capable of providing restitution or fixing what problems occurred. Safety, not only worker safety to protect your employees, public safety, environmental safety, and food safety. I mean, all of those things. Your company needs to be properly registered with the state and county, properly licensed, and you have to make sure that you are following all the state and federal laws and regulations. What are the grower responsibilities? The grower must inspect the contractor's license. If you hire somebody, you need to be shown their license and keep a copy of their license on file and make sure the license is active and recognized with the state's labor commissioner. So you've done your due diligence to know that they are a legal operating labor contractor. And you have 3 business days in which to do this. There's something called a 1099 miscellaneous where you pay the contractor and then the contractor in turn pays the employees. So you hire the contractor for, $40,000 to do this work for you, and then the contractor pays 35,000 as wages to the employees, taxes, and other things, and sticks 5 in their pocket for running the business. Division of Labor Standards Enforcement often deems farm labor contractors as firms that manage California agriculture land. So if you're a vineyard management company, you may fall under the labor contractor rules, even though you're not doing large labor in the same sense, you're still following under that category. If you are the management operation, a hired for guns, so to speak, hired company to manage a vineyard or orchard. Similar to what I mentioned before, there is a Labor Commissioner's Farm Labor Contractor Fund. So damages include wages and interest and any losses by an employee proved to result from violation of the law. So if a labor contractor doesn't do what they're supposed to do and an employee is left not getting reimbursed what they are owed, then this Farm Labor Contractor Fund can turn around and make that employee whole, give them what they should have gotten from the contractor in the first place. Migrant and Seasonal Agricultural Worker Protection Act. I think the name says a lot. There are lots of ag employees who move with the seasons, move with the crops, and that made them extremely vulnerable to abuse by employers and labor contractors. And there's a lot of history of migrant workers being victims of this particular hard to manage, hard to enforce population of workers. And so the MSPA is created to try to protect those, at least create some rules where if an employee comes forward, they have some legal status for their claims. And so here are a number of websites and other places to look for resources. Our own federal Congress, the legislative branch of the federal government, Department of Labor, Ag Relations Board, Department of Industrial Relations, etc. Fels.net, this is a private organization that helps employers, the Farm Employers Labor Service. I've had tremendous success over the years finding information that I wanted about worker safety, about all kinds of different things, heat illness prevention. Fels.net is has been, at least in the past for me, a very useful site. Western Grower Association, and they're, as the name implies, Western Grower, they're Western United States. The grower shipper is right here in Salinas. That is it for labor.